Sean Quigley here. My portion of the presentation will be on family-based immigration. Okay, the Immigration and Nationality Act is the body of law governing current immigration policies in the United States. Immigration to the U.S. is based upon the following principles: the reunification of families, admitting immigrants with skills that are valuable to the U.S. economy, protecting refugees, and promoting diversity. But first, a little history about this act. The first Immigration Act happened in 1924. It's what's known as the Johnson-Reed Act. This act limited the number of immigrants allowed to enter the country through national origins quotas. Available visas were not to exceed 350,000 a year. However, no quotas were established for people living in the Western Hemisphere. This widely restrictive law was generated over security concerns following World War I. The act implemented a literacy test that required immigrants over 16 years of age to demonstrate basic reading and comprehension skills in whatever language. It didn't have to be English. It also increased the tax paid by new immigrants upon arrival to our country. The act excluded entry from anyone born in geographically labeled Asiatic barred zones, which means they didn't want people from Asian countries immigrating to the United States. The Act of 1924 led to the Immigration and Nationality Act of 1952, also known as the McCarran-Walter Act. This act ended excluding Asians from immigrating to the U.S. There were concerns that the quota system from the previous act favored immigration from Northern and Western Europe, and therefore created resentment against the United States and other parts of the world. But it should be noted, it also introduced a system of preferences based on skill sets and family reunification. The Immigration and Nationality Act of 1965, also known as the Hart-Keller Act, followed the one from 1952. Most notably, it developed preference categories for immigration. One of the main components aimed to abolish the national origins quota. It created a 7-category preference system which gave priority to relatives of U.S. citizens and legal permanent residents, and to professionals and other individuals with special skills. This act actually changed the demographics of the U.S. Prior to 1965, 68% of immigrants came from Europe or Canada. From 1971 to 1991, immigrants from Latin American countries, their numbers jumped up to 48%, and immigrants coming from Asian countries, their numbers rose to 35% of all immigrants coming into our country. Which leads us to the Immigration Act of 1990. Most notably, this reform to the Act of 1965 provided family-based immigration visas, created 5 distinct employment-based visas, categorized by occupation, as well as a diversity visa program, which created a lottery to admit immigrants from low admittance countries or countries where their citizens were underrepresented in the United States. Family reunification remained a priority. The act expanded the number of family-based visas allotted per year, but to do this, it also made the definition of family more exclusive by limiting it to immediate family members only. There are 2 groups of family-based immigrant visas. The first one being immediate relative immigrant visa. This visa type is based on a close family relationship with a United States citizen, described as an immediate relative. That's what the IR stands for on the side of the screen, IR 1 through 5. So the immediate relative would be the sponsor for the immigrant coming into the country. So the categories are spouse of a U.S. citizen, unmarried child under 21 years of age of a U.S. citizen, orphan adopted abroad by a U.S. citizen, orphan to be adopted in the U.S. by a U.S. citizen, and parent of a U.S. citizen who was at least 21 years old. The second visa category is family-based immigrant visas. These visa types are for specific, more distant family relationships with a U.S. citizen, and some specified relationships with a lawful permanent resident. I didn't mention before on the last slide, but for the immediate relative immigrant visas, it's an unlimited number. So there's no restraint on how many people can come in on that visa program. With this one, each section has a limit of the amount of immigrants who can come in under that one. So the first one, Family First Preference 1, is for unmarried sons and daughters of U.S. citizens and their minor children, if any. And the cap for each year is $23,400. F2 is spouses, minor children, and unmarried sons and daughters aged 21 and over of lawful permanent residents. At least 77% of all visas available for this category will go to the spouses and children. The remainder is allocated to unmarried sons and daughters, and the cap each year for this is $114,200. F3 is for married sons and daughters of U.S. citizens and their spouses and minor children. The limit is $23,400. And the last one, F4, is for brothers and sisters of U.S. citizens and their spouses and minor children, provided the U.S. citizens are at least 21 years of age. And each year, $65,000 can come in with that. It should be noted that grandparents, aunts, uncles, in-laws, and cousins cannot sponsor a relative for immigration. You might be asking yourself, what happens if the numerical limitation on family preference immigrants reaches its max? Well, whenever the number of qualified applicants for a category exceeds the available immigrant visas, there will be an immigration wait. In this situation, the available immigrant visas will be issued in the chronological order in which the petitions were filed using their priority date. In certain categories with many approved petitions compared to available visas, there may be a waiting period of several years or more before a priority date is reached. In order to sponsor an immigrant coming in under the family-based immigrant visa categories, must be a U.S. citizen, 21 years or older to file a petition for siblings or parents. As a sponsor and petitioner, you must also be a resident of the United States. For social workers working with this population, it's important to understand the effects that having an undocumented parent or other family member in the household has on children and families. It's estimated that 25% of all children in the United States live with at least one immigrant parent. Between the years of 2009 and 2013, there were 4.1 million children who were U.S. citizens, but they had an undocumented parent living with them. The Migration Policy Institute did a study, and they estimated that between those years of 2009 and 2013, about 500,000 parents were deported. I feel like families are important, and keeping them together is best for everyone, and is the right thing to do. There are many long-term and short-term consequences due to the criminalization of immigration. Undocumented immigrants lack certain legal protections, which lead to low wages, labor exploitation, and poverty. Children whose parents are undocumented are less likely to be enrolled in pre-K educational, public programming, or other services, which include Medicaid, Medicare, children's health insurance programs, public housing, SNAP, and other forms of welfare assistance, even though they are legally entitled to these programs based on their birthright citizenship. And these are just a few examples of the problems this marginalized community faces. So it's really important for social workers to understand all these things, because it'll directly affect how you interact with people. Because eligibility laws often exclude certain classes of immigrants from access to programs and services, social workers are confronted with unique challenges when practicing social work with immigrants, especially if the practitioner is not knowledgeable about the various classifications of immigrants living in the U.S. Social workers must inform themselves of immigrant status types and their associated rights in order to best serve this client group. Undocumented immigrants often live in the shadows. and make great efforts to ensure their status is not detected. While having undocumented status, they are one of our most vulnerable groups because of the constant threat of deportation, causing them to often be exploited by employers and others who are aware of their lack of status. Having your family members arrested and deported or living in fear of this has negative impacts on mental health. If someone discloses their status to a social worker, it should be handled with the utmost confidentiality and care. Reporting someone with undocumented status may hinder others from seeking help from social workers. Also, it should be noted that undocumented people who are deported face a 10-year ban for legal re-entry into the United States. So if someone overstays their visa by just 1 day, they are subject to this bar, which is pretty excessive, I think. While working with this population, you may find yourself with a few ethical dilemmas. But we have our values in place, and if people follow the social work values, which I have written down on the screen, I feel like we'll be okay. Laws protect us with confidentiality, so if someone discloses their undocumented status with you, you don't have to share that with people. However, others may not know this, or maybe a new state law might be passed and they'll make you have to report it, but I don't think that's going to happen anytime soon. But standards regarding confidentiality are upheld by our values. Confidentiality is one of our core values that has a clear ethical and practical implication. It shows that our offices are a safe space for clients and where they can feel comfortable. It serves as a protective factor and encourages people who may have harmed others or been harmed themselves to come forward for help. Without this value, without confidentiality, our clients and our future clients may not engage with social workers. And this concludes my presentation on family-based immigration.